Thank you, Mr. Chairman. I have a unanimous consent request. This is a recent article from AP News. The headline is EPA eliminates mention of fossil fuels in website on warming's causes. Scientists call it misleading. This is an article, Mr. Chairman, about how the EPA is removing all references to fossil fuels as the cause of climate change, despite the global scientific consensus that it's the main cause of climate change. So very important, Mr. Chairman. I think that this committee acknowledged that our government right now is scrubbing this science from the record. This kind of erasure and cancel culture is not leadership. It's a disgrace.
Without objection, so ordered.
Thank you, Mr. Chairman. When the framers put pen to parchment and gave us the Bill of Rights, they made a promise about power in the United States, that no person would have to stand alone against the full weight of their own government. And that promise was solidified in the Sixth Amendment's right to counsel. The simple idea that justice should not be dependent on who you are, how much money you have, or how powerful your opponent may be. And that is why Congress passed the Equal Access to Justice Act in 1980, before EAJA. Ordinary Americans, people who did not have teams of government lawyers or corporate war chests, often had to defend themselves when the government violated their rights. EAJA helped ensure that when the government does that, when they break the law, that the victims are not financially punished for exercising their rights in court. And in a better political moment, this hearing would be a celebration of that achievement. After all, people all over the spectrum use this law to protect basic rights: conservative groups, liberal groups, farmers, ranchers, indigenous people, small businesses. Most of all, though, veterans and Social Security recipients. That gets lost in the fog of all of these politics here. They make up 99% of all cases, and instead, Republicans here would have you believe a different narrative, one that is contradicted by the actual evidence that environmental nonprofits and public interest groups are abusing EAJA with frivolous lawsuits. And yet, if you just apply a little bit of scrutiny, the entire basis of that phony narrative collapses. So let's get out of the MAGA echo chamber for a moment and visit reality. First, under the Constitution, all plaintiffs, including environmental plaintiffs, have to satisfy Article 3 standing to be in federal court. They've got to prove they've been harmed. And if they can't do that, there is no case and no award. Second, you got to win to get an EAJA award. That is not frivolous by definition. Third, attorneys who bring frivolous lawsuits can be fined by the court or even disbarred. You can ask your friend Rudy Giuliani about that. Fourth, EAJA reimbursements can still be denied if the court finds that government action was reasonable, even if it was technically illegal. So there's another layer of safeguard. And then finally, courts can still deny an EAJA award if they decide that special circumstances would make it unjust. And so I would say, rather than a law that we need to scapegoat, that we need to set up as a straw man to attack environmental groups, these are the hallmarks of a carefully restrained and judicially supervised law. And what my colleagues seem to actually be upset about is not the use of EAJA, it's the fact that environmental groups exist, and the fact that everyday Americans use this law to enforce environmental protection laws that they don't like, including laws that go against their preferred industries and hold them accountable. That's what EAJA sometimes does, and that's what makes it such a target for my friends across the aisle. Hollowing out this law is not fixing abuse. It is building a liability shield for polluters. Because here's the thing, if the federal government issues an unlawful permit, if they break the law and allow a company to clear-cut a forest around you, or dump poisonous mining waste into your river, or blast and drill next to your ranch or your sacred tribal lands, the court may be your community's last best hope to stop that illegal action. The conservative Mountain States Legal Foundation once put the issue very plainly, and I will quote them to wrap up, Mr. Chairman. When fighting a court battle against the government in defense of their rights, many people run out of money to pay the high legal costs involved, or they simply run out of willpower and give up." End quote. That conservative group was right. We should listen to them, and we should have real hearings in this committee, including on the affordability of electricity, costs of which are skyrocketing because of this administration's wrong-headed policies. I yield back.
Well, first of all, to the gentleman, I want to clarify that we're not having a hearing on Social Security or Veterans Affairs. We're having it over EAJA in regards to the nonprofit, the environmental groups.
And Mr. Chairman, is it not the same law, though?
Same law, but I think you would agree with me that it needs some tweaks.
So you're going to edit out some groups from being able to access the law? Is that what this is
Oh,
about?
I don't think so. I think
This
I
is
want
another
compliance like
political filter that
Well,
we're
it's not a
applying?
political filter. What I want to see is that if you take a dollar or a penny from the federal government in any type of restitution, you have to provide us where you're getting all your money from. I think we would agree on that, don't you?
I think that is a recipe for abuse and intimidation that clearly you are wielding.
Wait a minute. No. If you take money from the federal government has a right, we as the government need to have the right to know where that money came from, whether it's from a foreign source, whatever. That brings us down to a clarity aspect. So let me tell you.
So, Mr. Chairman, right now, you are going on a bunch of fishing expeditions against environmental NGOs because they've won lawsuits and they have opposed, for example, a mining project in the headwaters of the Boundary Waters. And you are making their life miserable by going into their finances, trying to open up their books, trying to go on this fishing expedition to find some tortured connection to some foreign money source. That's what you're talking about right now, right?
Well, you call it torture. I want clarity. If everybody has to do it, then I think it's
Yeah. Why don't you do that to fossil fuel companies?
Well,
Because in the last Congress, we presented smoking gun evidence that they were colluding with OPEC to jack up prices for American consumers. You were uninterested in that. So there's a really strange disconnect here about what you're concerned about and what you're not. But I love this debate. I want to continue this debate if you want to. This is actually far more productive for the American people to see and hear than this sham that you're about to take us through today.
well, I disagree with the gentleman. I think for his opinion, I've always regarded your opinion.
Thank you,
But,
Mr. Chairman.
From that standpoint, we'll let it go.